Does a patent rejection mean I'm infringing? One of the most common questions I get from inventors goes like this. The examiner rejected my patent application based on another patent. Does that mean I'm infringing that patent? If you've ever received an office action, especially one with a Section 102 rejection, you've probably had the same concern. Patent infringement and patentability are two very different legal analyses. Let's talk about that. When a patent examiner cites prior art against your application, they're asking one question. Is your invention new compared to what already exists? That's a patentability question. Patent infringement, on the other hand, asks something completely different. Does a product or process fall within the claims of an issued enforceable patent? So just because an examiner cites a patent against your application does not mean you copied it. It doesn't mean you're infringing it, and it doesn't mean that the patent owner could sue you. Examiners often cite references that would never support an infringement claim in the real world. Let me give you a real example here. The details, I'm going to change them for confidentiality, obviously, but the overall theme is what really happened. I worked with an inventor I'll call John. John received an office action with a Section 102 rejection based on a prior art patent. He called me and said, "This patent looks close. Am I infringing it?" So I said, "Slow down. Let's take a careful look at the cited patent." What we found was interesting. The examiner had cited some of the drawings from the patent, and visually, those drawings did look somewhat similar to part of John's invention. But when we read the claims, the part of the patent that actually matters for infringement, they were directed to something totally different. Different functionality, different problem being solved, different claim scope. It didn't touch on what he was doing. In other words, even though the drawings were close enough for an examiner to cite during prosecution, the claims would not support an infringement allegation against John. So once John understood that distinction, his concern went away. This situation comes up all the time because examiners are not doing infringement analysis. Their job is to test whether your claims are too broad in view of what already exists. That means they may cite expired patents, patent publications that never even issued, or even product manuals and technical literature. All of those can be valid prior art for patentability purposes, even if no one would ever enforce them against you for infringement. Now that said, if a cited reference seems similar to your invention, there are some smart follow-up steps. First, check whether the patent is still in force. Many patents expire and some publications never become patents at all. Second, focus on the claims, not just the drawings. And third, talk to your patent attorney. A patent attorney can dig deeper into the claims with you, the expiration dates, and whether there's any real-world risk worth worrying about. So here's the key takeaway. A patent rejection does not mean patent infringement. Remember, patentability is about whether you deserve a patent. Infringement, on the other hand, is about whether someone is violating the claims of an issued patent. They are related, but they're not the same. So if you have questions about patent prosecution, prior art, or infringement risk, feel free to reach out. And if this was helpful, be sure to like and subscribe for more practical patent insights.